Hi, I'm Pat O'Rourke, General Counsel for the University of Colorado. Today I'm going to speak with you about the legal requirements necessary to obtain a patient's informed consent before a proposed medical intervention. For the most part, I'm going to be describing the legal elements as they exist under Colorado law, but the elements of informed consent are fairly consistent across jurisdictions. To understand the elements of an informed consent claim, I first need to step back and discuss general professional liability claims against physicians. When a physician is sued by a patient, the claim that the patient most often advances is for professional negligence. A claim for professional negligence has three essential elements. First, the patient must demonstrate by a preponderance of the evidence that the physician breached a duty of reasonable care owed to the patient. In other words, the patient must demonstrate that the physician either took or failed to take an action that a reasonable physician practicing in the same or similar specialty would have taken or refrained from under the circumstances. Second, the patient must demonstrate that he suffered some type of legally cognizable injury, which can include physical injury, emotional injury, or financial injury. Third, the patient must prove that the physician's breach of the duty of reasonable care proximately caused the patient's injuries. Stated another way, if the patient's injury would have occurred irrespective of the physician's conduct, the patient cannot advance a legal claim against the physician. With this understanding of general professional liability claims against physicians, I can now address informed consent claims. Informed consent claims are a variant of a general professional liability claim, but occur when a physician has failed to disclose a risk of a competently performed procedure. Informed consent claims follow a similar format to professional negligence claims. First, informed consent claims do not center upon the medical care that the physician renders to the patient, but instead center upon the information that a physician provides to a patient who may undergo a medical intervention. The physician has a duty to provide the patient with the same information that a reasonable physician practicing in the same medical specialty would provide under the circumstances. Second, the patient must again demonstrate that he suffered some type of legally cognizable injury, and again, that injury can include physical injury, emotional injury, and financial injury. Third, the patient must demonstrate that the physician's failure to provide information caused the patient's injury. In other words, the patient must demonstrate that he would not have undergone the medical intervention if the physician provided additional information. Let's break down each of these concepts a little further. Duty. Respect for patient autonomy and the integrity of the person requires a physician, absent emergent circumstances, to obtain the patient's informed consent before a medical intervention. Notice that I have not said that a physician must obtain a patient's consent before performing surgery. While surgery is one of the medical interventions where a physician should obtain informed consent, the physician's duty to obtain the patient's informed consent is broader than surgical intervention and applies whenever a physician initiates a course of treatment, whether medical or interventional. And also notice that I didn't say that a physician has an obligation to obtain the patient's consent, but rather has an obligation to obtain the patient's informed consent. It is not enough to say the patient consented if the patient did not have sufficient information to make an informed decision. So the question becomes what information the law requires a physician to provide to a patient to make the consent informed. A physician has an obligation to make the patient aware of the known risks of a particular medical intervention, which is easy to say, but somewhat harder to define. Obviously, the range of potential risks that accompany a medical intervention is broad, and it might overwhelm both the patient and the physician if physicians were obligated to disclose every conceivable risk. The law, however, does not impose an obligation upon physicians to disclose every conceivable risk, but instead requires physicians to disclose those risks that a reasonable patient would wish to know before undergoing a medical intervention, which is somewhat more helpful, but still open to some degree of interpretation. Consequently, when I think about risks, I tend to think about them in terms of two variables, frequency and severity. If an adverse outcome is frequently associated with a procedure, it increases the likelihood that it should be disclosed to a patient. If an adverse outcome is severe, it increases the likelihood that it should be disclosed to a patient. Among the outcomes that I consider severe are those that can produce death, significant disability, inability to work or perform activities of daily living, and loss of reproductive or sexual function. If you had an intervention frequently associated with death, a reasonable patient would want to know that association. If you had an intervention that was infrequently associated with an insignificant complication, a reasonable patient is far less likely to want to know that association. Turning to benefits, the calculus is largely the same, and patients would want to know about the reasonably anticipated benefits of the intervention. To the extent that the patient presented with a particular complaint or condition, if the intervention is expected to cure or ameliorate that complaint or condition, a reasonable patient would want to know that association. On the benefit side, the physician should not only explain the potential benefits, but the likelihood that the benefit will accrue. Physicians should refrain from overpromising the potential benefits of a particular intervention or the likelihood of a particular outcome, as any misrepresentations could form the basis of an informed consent claim. And then turning to alternatives. A patient's decision to undergo a medical intervention can only be informed if the patient understands the potential alternatives. The alternatives that a physician must disclose are those that are generally recognized in the medical community, and a physician has no obligation to disclose alternatives that have not yet progressed to the point where the medical community recognizes them. A physician also has no obligation to disclose an alternative that he believes is medically inappropriate or contraindicated for a particular patient. Damages. The patient will need to demonstrate by a preponderance of the evidence that he suffered a legally recognized form of damage. The law allows injured patients to recover for many types of injuries. Some of the commonly asserted injuries include claims for medical expenses, lost wages, loss of physical function, pain and suffering, and loss of enjoyment of life. A jury would need to determine that the patient suffered the injuries that he claims in a lawsuit. Causation in an informed consent claim is different than in a general professional liability claim. In a general professional liability claim, the patient is claiming that the physician negligently caused the patient to suffer an injury. An informed consent claim, however, arises when a recognized complication arises from an intervention that the physician competently performed. The patient is not claiming that the physician negligently caused the injury, but rather is claiming that he or she would not have undergone the intervention if the physician had accurately communicated the risks, benefits, and alternatives of the chosen intervention. In other words, the patient must show that he would not have consented to the procedure had the physician provided different information. It is often difficult for a patient to demonstrate that, had additional or different information been provided, he would have withheld consent. Understanding that these are the elements of an informed consent claim, the next question is how a patient would establish such a claim against a physician. In legal proceedings, a party seeking to establish the claim has the burden of proving his claim by a preponderance of the evidence, which is a way of asking if something is more likely than not. First, the patient has the burden of going forward and presenting evidence that he or she was uninformed about a particular risk, benefit, or alternative of a medical intervention. Obviously, if the patient was fully informed, and the evidence does not create a genuine issue of whether or not the information was actually transmitted, the case cannot proceed. If there is a dispute about whether or not the information was disclosed, the jury ultimately resolves that dispute. Second, the physician then has the burden of presenting evidence that the standard of care in the medical community does not require disclosure of the particular risk, benefit, or alternative of the medical intervention. Finally, the evidentiary burden then shifts back to the patient to prove each of the following elements by a preponderance of the evidence. First, that the particular risk, benefit, or alternative of the medical intervention was not disclosed. Second, that the standard of care does in fact require disclosure of the particular risk, benefit, or alternative. Third, that the patient would not have consented to the medical intervention if the appropriate disclosure was made. And fourth, that the patient was damaged as a result of the inadequate disclosure. If the patient is unable to prove each of these elements by a preponderance of the evidence, the jury must find in the physician's favor. When presenting evidence about whether the standard of care required disclosure of a particular risk, benefit, or alternative, the patient must present competent expert testimony. Matters related to medical diagnosis and treatment, as well as the standard of care expected of physicians, are matters beyond the competency of most laypersons, and a patient is not competent to testify on these subjects. Accordingly, the patient is required to present expert testimony from a physician who practices in the same medical specialty as the defendant to establish a breach of the applicable standard of care. Experts are allowed to testify about their opinions because they have particularized training, education, and knowledge that allows them to assist the jury in determining the disputed issues in the case. Without expert testimony, the jury would not have a sufficient basis to decide the case. Ultimately, however, after hearing the evidence, the jury is charged with the ultimate task of weighing the testimony in the exhibits and determining whether the patient has carried his evidentiary burden. I am often asked how physicians should document their informed consent discussions to best allow them to defend their care in legal proceedings. Although there are hospital policies and forms that apply in many institutions, the law does not mandate any single method of documenting an informed consent discussion, and it may not be possible to document everything that occurred during the course of the discussion with the patient. What I generally recommend is that the physician document any well-recognized and significant risks, benefits, and alternatives, and in particular those risks that are likely to be life-altering or permanent. What I do not recommend is that the physician include in the medical record a simple statement to the effect of, discuss the risks, benefits, and alternatives of the procedure with the patient. While this statement is better than nothing, it leaves the patient with the ability to deny that any particular risk, benefit, or alternative was discussed, and more importantly, because a lawsuit could be filed months or years after the care was rendered, the physician may not have a sufficient independent recollection of the conversation to explain that generic statement. That being said, physicians are able to testify about their habits, customs, and routines. If, for example, a general surgeon habitually and routinely discusses bleeding and infection as among the risks of an appendectomy, he would likely be permitted to testify about that practice. What is necessary for a judge to admit this testimony, however, is for the physician to testify that he, in fact, has habits, customs, and routines for a particular procedure. Physicians should consider the medical interventions that they regularly recommend for patients and think about how they can establish habits, customs, and routines that inform their practices. Finally, it's important to remember that informed consent is a dialogue between physicians and their patients. Where there is a good relationship between a physician and a patient, when the patient has been able to ask questions of the physician, and when the patient believes that the physician has answered his questions to the best of his ability, the possibility of an informed consent claim greatly decreases. The time that a physician spends with a patient to ensure that he understands the risks, benefits, and alternatives to a particular medical intervention is time well spent and can help the physician avoid litigation.